All right. Good afternoon, everyone. Thank you for being here. If this is your first InnovationU, welcome. If you've joined us before, welcome back. My name is Coté Walston, and I'm with Texas A&M Innovation. I'll be serving as your host today and moving forward as a consistent point of contact for InnovationU sessions. InnovationU exists to provide practical guidance for faculty and researchers navigating innovation and commercialization at Texas A&M. Specifically, how ideas move from the lab into real-world application. One thing we've consistently seen across the system is that there's strong interest in commercialization, but not always clear visibility into how to engage or where to start. InnovationU is designed to help close that gap by making these processes more accessible and easier to navigate. These sessions focus on real, recurring situations we see across campus, protecting intellectual property, engaging with industry, forming startups, and understanding commercialization pathways, with an emphasis on practical application. For today's session, we're focusing on engaging with industry while protecting TAMUS intellectual property. This is an area where we see a lot of uncertainty, particularly around what to share, when to share it, and how to move conversations forward without creating risk. These situations often happen early, before there's a formal structure in place, which is where issues tend to arise. Today is about giving attendees practical context that they can apply when these moments come up. At the end of the day, the goal isn't activity, it's impact. The more clarity we can provide early, the easier it is to translate research into real-world outcomes. As many of you know, our role at Texas A&M Innovation is to help translate research and ideas into impact through protecting IP, licensing technology, forming startups, and facilitating industry engagement. We work across that entire life cycle, from early disclosures through commercialization. If faculty are thinking about sharing research externally or engaging with a collaborator, that's typically the right time to connect with us. Earlier engagement is almost always better, especially when IP is involved. A key part of that support comes from our licensing team, some of whom are in the room today. They are often the primary interface for faculty, working directly with them to evaluate opportunities, protect IP, and guide next steps. They also bring visibility into common challenges and opportunities across the system. InnovationU is one of the ways we aim to make that expertise more visible and accessible over time. With that context, today's discussion will focus on how to approach early conversations with industry partners and external collaborators while safeguarding intellectual property. We'll move from a moderated discussion into audience Q&A, followed by networking. I'll now turn it over to our moderator, Janie Hurley, who leads our licensing team and brings nearly 3 decades of experience working directly with faculty to develop commercialization and IP strategies across the Texas A&M system. She'll begin by introducing our panelists and then lead the discussion. With that being said, Janie, the floor is yours.
All right. Thank you, Cody. Well, good afternoon. I should say howdy. Thank you all so much for being here. We really appreciate you spending your afternoon or part of your afternoon with us. I'd like to just kind of survey the room before we start. How many are faculty in the room? Very good. Okay. Do we happen to have any representing industry in the room? Ah, okay. I may have to ask you to speak out, to step out. No, I'm kidding. I'm just kidding. I hope no matter your affiliation that everyone will get something out of our discussion. It should be very interesting today. And I know that we also have folks joining us online. So hopefully you'll find some good tidbits out of our discussion today. So I'm going to give a brief introduction of our panelists. So I'm going to start at the end here. We have Dr. Jerry Coté. He's an Associate Agency Director of Texas A&M Engineering Experiment Station, leading the project offices for health initiatives, strategic advanced research, and industry engagement and entrepreneurism. Goodness, that's difficult to say. He's a professor in the Department of Biomedical Engineering and recognized globally for his translational and fundamental bioengineering research contributions in diagnostic and monitoring applications, including wearable and handheld devices, as highlighted in his over 500 publications and talks. Dr. Coté is the co-holder of over 25 patents and patents pending. He's active in research and engagement with dozens of companies, and he's a co-founder of 5 of his own medical device companies: Omnicentrix, Cardiatex, Biotex, Base Pair Biotechnologies, and Visualaze, which was acquired by Medtronic in 2014. Dr. Coté is also a past recipient of the Chancellor's Innovation Award. Next, we have Sabrina Allan. She's the director of Texas A&M AgriLife Contract Office, where she utilizes her combined background in science and law to facilitate research and support the state's land grant member mission. She earned her bachelor's in genetics and a master of biotechnology from A&M before beginning her career as a licensing assistant in the tech transfer office here. She later pursued her legal education at South Texas College of Law, becoming licensed to practice in the state of Texas. While practicing in both Houston and Dallas, she dedicated time to pro bono service through the Veterans Legal Initiative. In 2014, Sabrina and her husband relocated to Bryan College Station, where she has since negotiated contracts supporting complex research relationships. And don't say that lightly, complex research relationships. I've seen many of them myself, concentrating on commodity and for-profit private industry sponsored collaborations. And then last but not least, we have Dr. Robert Hanson. He's a partner and chair of Dentons U.S. Intellectual Property and Technology Practice and a member of the Forum's U.S. board. His practice focuses on patent counseling and prosecution in biotechnology and the life sciences. Rob has prosecuted more than 4,000 patents to issue in the U.S. Yes, that number was 4,000, and managed foreign patent portfolios worldwide, advising leading university, industry, and nonprofit clients on all aspects of strategic patent portfolio management. Recognized in Chambers USA, the best lawyers in America, and among the top 10 ranked patent prosecution attorneys overall in the United States by Patexia. He brings deep technical expertise in biotechnology and genetics to his work with clients across the life sciences. I honestly don't know what I'm doing sitting up here, but anyway, I just really appreciate you. You can tell we have a very knowledgeable panel with us today, and so hopefully you'll take advantage of it. So as Cody mentioned, we're going to open up the floor for questions a little bit later, but we thought we'd start off the conversation with a few questions and just kind of take it from there. We want you to have the benefit of asking questions that are burning on your mind, but we want to get the discussion started with some questions. Okay. So first question, what is the biggest misconception faculty have about working with industry? See, maybe Sabrina, do you want to take that one?
I would say, can you guys hear me okay? Okay. I would say it primarily comes down to, industry always works quickly. And private industry, is always on the ball, they're ready to go, they've got the contract and they can turn it around in a few days. Typically, that's kind of the impression that a lot of folks have. And when we do negotiate, and that's kind of what our office, whole half of our office is dedicated to, working and doing contracts with private industry. A lot of them, some of your smaller shops or your startups may not have in-house counsel, for example. They might have to go and work with outside counsel. They may not have a dedicated contracts office. And some of your larger entities may have gone the other route where they have really a dedicated subject matter expert for every section of that agreement. It could be compliance, it could be intellectual property. It can span every arena, and you might have 5 or 6 attorneys and compliance officials looking at one agreement. And so it really can span. It depends so much. And we're probably going to hear the words, it depends a lot today, which is probably one of our favorite phrases, I guess, or one that we have to use quite often. But it depends on the complexity of the project, what the interests of each parties are, and everything else. And so they can be quick. I don't want to say that they can't. They can be, but sometimes they can also be complicated.
Great, thank you. Dr. Coté, do you have anything to add to that?
Well, I think I agree wholeheartedly with Sabrina. It's all over the map, but a lot of you'd think a large company would be quicker, or a small company might be more nimble and quicker. And no, the small company doesn't have an in-house counsel, so they sometimes have to contract it out, and that takes a while. So, and the small companies that I've worked with tend to be a little bit more skittish because they're small companies, and A&M's such a big entity. They feel like we must have this cadre of attorneys that are ready to jump down their throats. And so, so you do get some of that delay. But I would say that the faculty can be, and I may use this word a few times, is influencers, right? You can't negotiate on behalf of the university, and you can't negotiate on behalf of the company, but you can influence the process. So whether the process is being held up on our end or whether it's being held up on their end, you can talk to your technical lead at the company, and they can usually influence their process. And if you get to know these guys well and treat them well and with respect and dignity like they ought to be, then I think, and take them out for a cocktail or something every once in a while. I like to do that too. But yeah, so I think you can grease the skids, if you will, or move things along a little better if it's being held up for this reason or that reason. Obviously, if it's breaking state law, you can't do anything about that. If it's breaking federal law, you can't do anything about that. But if it's just a matter of percentages on a contract or something like that, you can say, well, look, my IP is pretty cool, but it ain't that cool. So, let's go down a percentage or something like that if that's going to get the deal done. So I think you can be influencers, but I think, that is kind of your role in the process. Let the experts do what they do best, and you work with your technical lead to try to influence the process if it's not moving in the direction or in the speed that you need.
Okay, thank you. So starting to talk a little bit and venture into the topic of intellectual property, and Rob, I'm going to put you on the spot on this one. How might a researcher describe an invention or an idea to solicit potential interest from industry, but not give away too much that might jeopardize IP protection potential?
Well, anytime you're before filing for intellectual property, it's problematic. So you could lose rights. So there's a question later on that we'll talk about public disclosures. But if you disclose to somebody who's not under an obligation of confidentiality to you, then you could lose those rights. So that's problematic. So really, you should, before you go into that conversation, you should have ideally, assuming it's patentable technology, you should have a patent application on file and an NDA. Of course, you're talking to me, and I know that there's finite money that exists, but really, if you don't have those protections, I think you really can't give away any kind of confidential information and not cause potential problems for loss of IP.
Okay. Okay. So I'd just comment, one thing that I think about sometimes is there a way for you to share, to mention what you're thinking something does without saying how it does it? That's something to think about. But when you're in the really, really early stages, it's kind of difficult. I think one of the things that's important when you're engaging with industry is not only talking but listening. What kind of problems are they looking to solve, and trying to better understand what their needs might be, to then go back and think, what you may already be working on, or that you could work on that could help address those needs. So thinking about, it was mentioned in NDA or confidentiality agreement. So So it definitely, if you're wanting to share something, begin to share something that may be sensitive with the company, it's definitely advisable to have a non-disclosure in place before sharing that with a company or an outside party. But there are other things that sometimes we forget about. Once an NDA is in place, are there additional guidelines I need to be aware of for what I can and cannot discuss or exchange with the other party, with the company?
Well, one potential pitfall is, if you go into a meeting with a third party and everybody starts talking, people come out of that meeting with different recollections of who invented what. So you want to make sure that you have good documentation. I mean, ideally, you will file a patent application on all your inventions, everything that's relevant before that meeting. Because once you go into that meeting, in the United States, but in the old days, we used to have a first to invent system, and that simply means if two parties file a patent application, it would be the first person to invent that invention would get the patent. Well, now we're in the United States, we're in a first to file regime. So basically, if you go in a meeting and then they beat you to the patent office, it's going to cause serious problems. There are laws about derivation. So let's say hypothetically, you go into that meeting and you're the one who discloses something and you actually invented it, and they take your idea and they file on it. That's a no-no. They're not supposed to do that, but that's very hard to undo once somebody does that. So you really, before you go in there, if you're going to be talking about different ideas, if you're going to talk to your scientists are going to talk to their scientists, it's always best to have that provisional application filed so that you've kind of established that was your idea and there's no dispute about it later.
Right.
Just to add on to that too, coming from what we see a lot of times is, do I have an NDA in place is one of the first questions that really, if you may have signed one, the question is the purpose, is who the company's with, is that the correct legal entity? A lot of these larger entities do have multiple companies under their wings, for example. We want to make sure that, if you're entering into discussions or maybe they're an affiliate, that NDA actually does cover the discussions that you're going to be entering into, or maybe you entered into it a year ago. Maybe the question is it still active? Those are things that any one of the contract offices here that services TEAS, TAMU, AgriLife, they can tell you. We also want to make sure that the purpose of those discussions is covered. So one of the questions that we ask faculty is, what are the intent of these discussions? We want to be able to capture that by also still leaving some flexibility there. But there is, there's reasons for that. So if there's ever a question of whether or not, your NDA you have will actually cover what you're trying to accomplish, just let us know and your respective office can pull it and make sure that you're covered or get you an NDA so you can.
Mm-hmm. Mm-hmm.
I think that's a great point. Yeah, a contract, there's this concept in contracts of privity, and that simply means a contract is between two parties. So the party that executed it, yeah, it binds those two parties. But first of all, if they didn't have authority to sign, then then there's nothing, and you have to make sure that it's the right two parties that are in the meeting that are actually subject to the contract obligations.
Yeah, definitely.
And as a faculty member, you don't have the authority. So
Mhm.
keep that in mind. So you have to work with either TEAS or AgriLife or the system office to sign an NDA. They sign it, you don't sign it. So that's one of those situations where, especially junior faculty in particular that aren't familiar with the process, often a small company will send them an NDA and they'll say, oh, okay. And the company will even put the faculty member's name on the bottom because they don't know. And then the faculty member signs it and sends it back, and it means nothing because you can't sign on behalf of the university. So keep that in mind, that if there is an NDA to be signed, it has to be one of your offices, one of the state agency officers has to sign that because it protects the agency, not just, and it protects everybody in your lab or in TEAS or in AgriLife for whatever it is you're talking about. So if one of your students says something, they're under that NDA.
And there's one other quick point. We do have situations where folks will say parties A and B, you're representing the university. Let's say you're speaking with company ABC and they say, hey, look, company 1, 2, 3 would be really great to be a part of this mix. They're not going to be covered by that NDA unless you had them in the thought process in the first place and did a 3-party agreement. So if we need to amend an agreement or if we need to ensure that they're also covered by confidentiality obligations, let us know. Sometimes it'd be worth postponing that discussion, or you'd have to modify your discussion topics accordingly.
Right. and this is very specific, but one thing when we were talking ahead of time about this topic today, under an NDA, that if you have tangible materials that you're intending to send to the company, please don't do that only under an NDA, because most of the time an NDA is only to cover the exchange of information, not biological materials. And so just lots of things that when in doubt, ask your contracts office, ask someone to review the NDA for you ahead of time, so you know what you can and can't do under that NDA. So one question, I think, going back on, the thought of intellectual property. So sometimes there may be a question, should I submit an invention disclosure before engaging with the company in detail on a potential project? So that may be a question primarily for me to address. I would say that, if you have something that is a new discovery, it's always good to get that on record as an invention disclosure with our office before getting too far down the road and talking with an external party. It's good to have that documented, even if it isn't at a stage where we might file a patent application yet. At least having an invention disclosure and having an opportunity to talk about it ahead of time is a good idea. I don't know, Dr. Coté, if you have anything else to add on that topic.
No, definitely file before you do anything. Some people think, oh, well, it's my publication, so I don't have to file because it's my stuff. And it's like, no, well, as soon as you publish it, it's now open domain. And so it's not that hard to file a disclosure, and it's not that expensive. And so I recommend you do that before you publish anything, before you go to a conference and anything like that. I got burned as an assistant professor with that, where I filed after I went to the conference, and the patent office caught the conference proceeding was like 3 days before I filed or something like that. And so it was ineligible to be patented.
Yeah. And on that topic, maybe Rob, in regards to protecting IP, maybe you can go ahead and mention how public disclosure of enabling information impacts patentability.
Yeah, so I kind of mentioned before, any public disclosure for purposes of foreign rights will immediately destroy IP rights for what's publicly destroyed or publicly disclosed. The United States does have a grace period. We don't like to advertise that too much, so there is a 1-year grace period in the United States. But for foreign purposes, any public disclosure will immediately destroy those IP rights. So you really want to avoid that. For any company, those foreign IP rights can be very important. Now, what is public? Well, it really turns on accessibility, public accessibility. So, like, for example, a dissertation, a PhD dissertation, once that's accessible to the public. So there's kind of back when there used to be paper, there's kind of a very old law school case where there was a dissertation that was kind of in the back shelf of the library, and for a while it wasn't indexed. So it was kind of determined, okay, nobody could really get access to that. Well, at some point it became indexed, and basically the court said, okay, the day that was indexed, that was accessible to the public. So obviously in this day and age of internet communications, pretty much anything that's on the internet is accessible, right? So assuming Google can find it, or any other service can find it, then it's accessible. So the second you put that out there, and that includes abstracts. So sometimes we get questions that say, oh, it's just a poster abstract. Well, usually those, pretty much almost anything you put in the abstract, unless you make it completely useless, will kind of point toward the invention. And that's just one piece of prior art that will cause problems. Another situation I'll mention is public includes anybody who's not, like, for example, any non-university employees. So university employees have an obligation of confidentiality to the university. But one example of that would be, we had a inventor one time at another university who of course they would never do this here, but they had a parents' night. So the inventors had a parents' night, and they invited their parents to come look what they were doing. Well, those parents weren't under an obligation of confidentiality to the university, so that basically served as a public disclosure. So you really kind of have to be careful. Get your or talk to the technology transfer office early, get that NDA in place, and then kind of be careful with any kind of public disclosure.
Absolutely. Oh, goodness. Okay. So let's
Got a
go
question from over there.
back of what is that?
Well, we have students who are working on projects, right? They need to present.
Yes.
At conferences, at whatever. If we have an in-house local project, Texas A&M students, and they present the work together with an abstract, does that count as a public disclosure?
If it's in-house and nothing's accessible to the public, so the public's not invited, non-university, employees or anybody who's not under an obligation of confidentiality, if they're not invited, then that's fine. But if you invite parents, if you invite members of the public, that would be considered a public disclosure.
So if we have like vendors, so while we have our presentations, our poster presentations, that would be a public disclosure?
Only if it's if it's internal and the members of the public aren't allowed to attend, then that's fine. But if people from the others from the outside the university can come and attend, then that would be public.
And we would need to be cautious about students. So some students, they're employees, right, through but we also have, if there's students that are joining that are not employed by the university, that might be another
Great point.
another wrinkle.
Mhm.
Mhm. Okay. So let's go back thinking about, okay, you want to work with industry. You're exploring a potential relationship with a company for sponsored research. So I'm going to put Dr. Coté on the spot. How do you determine what industry partner that you want to engage with?
Yeah, so the first thing I do is meet with them and find out if they're relational, right, for me, right? And so I've often said I'd rather work with the second best person in the world if they're fun to work with than the best person in the world if they're a total jerk. And sometimes you can't tell that, but often you can tell that right off the bat. As soon as you start talking with a company, especially a small company, and how protective are they and how open are they? Not with IP necessarily, but just, how social are they? And usually your gut can tell you that, hey, this is going to be a problem. They're going to end up, and sure enough, if you do, and we have done this with some companies in the past, and they're just a thorn in your side for at least a year and a half before they finally go away. But so to me, it's much more about the relational aspect of the company. Is this somebody I want to work with? And this could be hard, particularly for an assistant professor that's, living day to day on grants and that type of thing. And so the company offers to give them $100K. Well, for an assistant professor, $100K is a lot of money. And so they can get a lot done and pay a student for a year and some supplies. And so often they end up working with this company, and then they're miserable for that year. And the company, they do what they call scope creep, right? And so they give you $100K and then they want $500K worth of work. So I would say, yeah, it has to be a relational, because at the end of the day, you want to do good things together, right? And so or at least you should. So that's the one thing I look at. And the other thing I look at is, am I the right person? So I kind of speak on behalf of the whole university. I try to, when it comes to the technical background, not when it comes to anything contractual. I don't speak at all. But when it comes to the technical background, if they need a biomechanics person, or if they need an energy person, or I work at a company now that build houses, right? I don't do anything with that, but I know the people in civil that do that. So I put them in touch with those folks. So I think to work with a company, it doesn't have to be you. If you're at the university, look and try to help your colleagues out, right? There might be somebody that has the expertise. There probably is somebody that has the expertise at this university. We're huge. It's just a matter of finding that person. So that's the two things: relational. If the relation doesn't sound good, I'm not going to pass them off to somebody else. And so, but then secondly, if the technology, if I can't help solve their problem, like Janie said earlier, find out what their needs are first. And if you're not the person, then don't pretend to be, but don't dismiss it either.
Mm-hmm.
Throw a bone to one of your colleagues that might be able to help.
You had mentioned scope creep, and I'm so glad that you did. One of the areas that we negotiate quite often with industry contracts is, milestones, deliverables, expectations. And one of the things that we really like to focus on is, when you apply for, let's say, a grant, there might be bios that you submit, and you might have a 60-page application. Industry typically is quite different. You've met with each other, you've built this relationship, hopefully, and like Janie was saying earlier, and I can't emphasize that enough, and it's an excellent point, which is listening to industry and what are they trying to solve and why they are trying to solve it. Because when you can curate your work to that, it'll have, great impacts for them and, hopefully for your research area. But scope creep is something that we do have to deal with in negotiations. And that's why your contract negotiator, for example, will ask you about the milestones and expectations and what are they going to provide you and what are you going to provide them, and why a thorough scope of work is so critical when we're looking at, contracts with private industry to ensure that everyone's on the same page, understanding what the expectations are. And then as things change over time, because we know not every hypothesis works out exactly like we think, right? The day you start, you might need to amend that agreement over time or pivot in your work and try a different methodology. And that's definitely another time to engage contracts office as well.
Okay, thank you. So, so back to you again, Sabrina. At what point should the contracts office be brought out in for a faculty member that has identified a company they think they want to work with?
As soon as possible. One of those things, especially with new faculty, researchers, anyone that's going to be engaging with industry, if you want to just talk with someone in our office that handles private industry agreements, we're more than happy to do that, even before you really get to doing those engagements. But when we have industry that has not worked with us before, maybe it's your first time working with them, we highly recommend doing an intro call with our office and theirs. One, especially if we haven't worked with them, to understand their business model. What are things that we can do? So when we initiate discussions, we're not throwing something over to the other side that they just can't do, contractually. There are things that we can, kind of curate. So really just as soon as possible. It also enables us to, if you need an NDA for those discussions, our office can get you an NDA. Any of the contracts offices on campus, whether it's TEAS, TAMU, AgriLife, they will be able to point you into the direct, the point of contact to get that agreement in place. So, our office, for example, does those non-sponsored agreements, and then we also handle private industry. So a lot of those NDAs hopefully lead to sponsored projects as well.
Okay, great. So when companies fund research, what outcomes do you think they're trying to achieve? Dr. Coté?
Yeah, so they usually have a set of milestones that they need you to get done. And this could take the form of non-IP too. We haven't talked about that, but some of this can be fee for service. And so our lab is set up in both ways. We can take research contracts and the way I break it down is if it has any chance at all of being IP bearing, then try to set it up as a research contract. But if it's a fee for service, they just need to come in and use your XYZ machine and use some of the time of your engineers to run these samples for them. There's no IP, then that could be that. But that's where the listening comes in. And I think you have to figure out, okay, what exactly do you need done and how can we help to get you there? And what's the most expedient way to do it? And so, so getting them involved early and asking those types of questions, and I think is the best thing you can do.
Yeah. Okay. Thanks. So do you think, Sabrina, do you think that companies most of the time believe they're going to own any resulting IP out of the work?
I mean, I really think it varies. So some companies, yes, come in with that position, especially if they haven't worked with universities before. Our university policy is that what's created here by our employees is owned by our employees. What, let's say, a sponsor creates is theirs that they own, and it really depends. We find out right away, honestly, if we get their agreement, which they call their paper, if they send it to us, it's usually pretty obvious what their position is on intellectual property. And then when they get the, OGC blessed, agreement from us that's curated to a research institution and to system policy, and they make their first red lines on it. Sometimes they're really pretty bloody. Sometimes, they might be more minimal, but a lot of times they're focused in the IP sections, the confidentiality sections, and publication sections. So we usually find out from the beginning, but that has not stopped negotiations or allowed us to find a way forward.
Great. Dr. Coté, did you have something to add to that?
Yeah, I think that's true. I think most small companies that haven't worked exactly what Sabrina said, they have no clue. They think, oh, well, I'm paying for it. They think you're a contractor, right? You're not a contractor. You're doing research for them. And so you're going to be developing IP. A contractor means you give me all the design specs, you give me everything, and then I build it for you. And if you're doing that, then you can do that as a fee for service. But if they come in and there's any kind of research, well, that could potentially generate IP. They're not paying for the IP. They're paying for you to figure it out. And then they can license it. And so I think that's a subtlety that most companies don't understand, that haven't done it before. Now, that being said, we did have a way to get around that in the past called Plan B. And I don't know if we want to talk about that tonight, but at any rate, there are ways that I think doesn't break state law that allow you to do that if they pay more money up front. And so then there's like a blanket agreement, and there, we don't like to do that too often, but in some cases it's probably worthy if, if you've got a big company that's, donated $20 million. I think that's where it came from. There's companies out there that have been giving research contracts to A&M and, in the near $100 million range. I think that's where that came from. And so any IP we develop is not probably going to amount to as much as what they've given in research. And so then, we can do that on a one-off basis, but that shouldn't be the norm.
Well, when we negotiate contracts, at least with industry, we don't necessarily always throw the basic research, substantive research contract over to industry. There are projects that are more services, testing, component related. When I say a sponsored research agreement, I'm talking about from anything from basic research to applied routine testing. But that's where we might get some miscommunications with our researchers. And so we're working on kind of changing that to it's a sponsored project, whether it's your basic testing, routine testing, services type work, or if it's more in the substantive basic research. And the IP terms with those might vary a bit. We really don't go into heavy IP terms and conditions in your services testing type agreements. It's mostly based on the deliverable of the output from what's tested, let's say for a field trial, or if you're just wanting to get some stand counts on plants over time. They're not anticipating intellectual property out of those. So we may not actually have to go in depth on intellectual property negotiations in every industry contract. They can be, believe it or not, they can be somewhat straightforward.
Right. Thank you. I think that is a big, sometimes a bit of an explanation up front that has to occur, that companies coming in just expecting that they're going to own all the IP, and really what they're paying for is the work that's described in the scope of work, and really any resulting IP coming out of that work is kind of a bonus. And so the budget was built for the purpose of doing the exact work that was described in the scope of work. Any resulting IP is kind of on top of that. And so we have to help the company understand that there's an additional value for that. And sometimes it can be a little bit more of a struggle than other times. So on that, we do have some flexibility in terms, I think, as you've heard, but there are some areas that we really don't have flexibility. And I think, Sabrina, maybe you could touch on a few of those.
I mean, a few areas would be, and I know that this is going to be a concern for most, publication, right? It's not to say that we haven't negotiated in that area, but with keeping in line, making sure that our agreements are within our mission at the university is critical. And also ensuring that, those, sometimes it's the student gets access to working with industry, and that's a great benefit. But we want to ensure that when they do have something, especially if they're doing something for their thesis or dissertation, that they have the ability to publish at the end of the day. Because all in all, we are also a research institution. So a lot of the conversations that we have, we might change scope on a project or split projects depending on what the IP position is, let's say of industry or in the publication opportunities there, to ensure that we can be pretty creative, but we just need to know ahead of time, especially if a student might be affected publication wise when those conversations come up. We do have the opportunity through the Office of Graduate Studies, I think, to delay a publication of a thesis by, I think it's 1 year. We've worked with those types of things in the past to ensure kind of give industry comfort that things aren't going to be going out the door right away. But those are the types of things that we would try to cover.
Okay, great. So just a few more questions, and then we'll open it up for questions from the audience. Once a relationship is established with the industry partner, do you have advice regarding do's and don'ts with regards to exchange of ideas in discussion with the company? Rob, do you have any?
Yeah, I mean, I kind of touched on this a little bit before. It's just that everybody, there's that risk when you start exchanging ideas with inventorship. So basically, ownership of a patent follows inventorship. So let's say you have a university that have 5 inventors, they invent this whole complex invention. If let's just say hypothetically somebody from industry is one inventor, contributed something, some part of this big machine of this whole, there's one inventor. If that person's a co-inventor, then basically you have two owners of that patent, and they both have full rights. So in theory, if you have 2 owners, one owner would have the ability to license it to a nickel for somebody else if they wanted, theoretically. So that's just they both have access to the whole bundle of IP rights. Now there are some things that we can do. We can say, okay, well, we're not going to claim that other thing that they invented, but you just have to be kind of aware in communications about this. The same concept I talked about is just kind of be careful to document. And then also of course, there can be disputes about who invented what, but with careful documentation and preferably figuring out who document who invented what before the meeting, then hopefully that avoids any kind of disputes after the fact.
Okay, thank you. Sabrina, real quick, back to you. Do you commonly find that companies are actually asking about having licensing terms included in sponsored research agreements?
So for the basic research agreements that I was talking about, where we might anticipate intellectual property, that's provided. We always start off with that. In that, if something does come up out of research, which of course we always hope that it does, and it, with that disclosure, which again, it's always important to disclose to your innovation office, there is an opportunity, an exclusive opportunity to negotiate for a commercial license. And that's one of the benefits to private industry, is that I always kind of use a relationship kind of example. We can't go date anybody else, right? We talk to the sponsor, we say, here's what came out of this research. You've engaged your TI office. They have those conversations. We can't go shopping around, right? Industry, one of their benefits is, you've been working on this work with them. They have funded it. And, anything that comes out of it, they have the first bite of that apple. If they pass on that opportunity, of course, then that's an opportunity for us to then talk with others that might be interested in that intellectual property. But the other side of that is if it's true testing services, and we're really just talking about something that's routine, the company may have provided you a 10-step plan. Hey, do this. Tell me if you get the results. Maybe they're doing a verification. Maybe they're doing 10 different studies in 10 different areas to see if the results are the same. And they're not anticipating intellectual property from that, and it's true testing. We wouldn't even need to go into those licensing terms and conditions. That's not to say that sometimes industry still doesn't ask for that. We still do sometimes end up having to negotiate those terms, even though it's very highly unlikely and not really part of that scope of that research. But some companies do require that, and they feel more comfortable engaging with the university that's willing to do those types of negotiations on that intellectual property language, even if unlikely.
Okay, thank you. So just a quick other comment on that. So if a company is trying to insist on the financial terms for a license at the sponsor research agreement stage, one of the things that we try to explain to them is we can start talking about terms, but those may end up being very favorable to us or very favorable to you. We don't know what the resulting intellectual property is. We can take a guess at the early stage, but in the end, I mean, there could be some wonderful new discovery that surprises both of us. And so how could we really set out and determine what the value is at such an early stage when we don't know what the subject matter is in the end? So, okay, I'm gonna stop right there as far as our kind of prepared questions and open it up to see if anyone in the audience has any questions. Yes. Do we have a mic for?
So there are microphones in the room, so as long as you speak clearly, you'll be heard.
Oh.
So what's the difference in filing a disclosure with the innovation office versus the patent application?
Very good question. So your invention disclosure to the innovation office does not represent a patent application filing with the patent office. So definitely make sure to understand those are very different things. So the invention disclosure to our office is just a form that asks questions about your invention so that we can gather the information and begin to assess what your invention is and gather all that type of information and make a determination on many different things. Does the university own it? Are there other outside inventors? And is there commercial potential here? Is there IP potential here? So we have to conduct that assessment, and then at the end of that, we make a determination. Is this something that we feel like we can, work with the work with outside counsel like Rob here to prepare a patent application and then file that with the patent office?
And one of the questions on that,
You maintain some level of confidentiality because a disclosure doesn't protect the invention.
Yes. Correct. The invention disclosure doesn't protect the invention. That's right. So the NDA or the confidentiality agreement, if you file an invention disclosure with our office, that's starting the process internally. But then if you want to turn around and talk to an outside party about that invention, then you need to work with us to get a confidentiality agreement in place before you talk to that outside party, or that potentially is a public disclosure.
and one of the questions on that form is what funding is used to fund that research that, prompted that invention. Their office pulls the sponsored agreements, right, that our office negotiates. And that's why we are very collaborative. And when we negotiate certain terms and conditions, or if we have to get really creative, I'll call Janie, and we'll do that. But we have obligations to our industry sponsors, and we have to let them know promptly on inventions. And that's where the TI office is going to be working with you as well and help curate that. One of our goals is, for researchers to be able to really focus on their research relationships with industry and in their collaborations, and help let us help, and also through the TI office, guide those more administrative discussions on that to ensure that you are protected.
Yes.
I don't have a comment about that non-disclosure agreement. One thing I was thinking, does the standard language have whether you have to reduce to writing your discussion? Because that is very, if you don't mind, bring that up.
Yep.
No one ever wants to write anything down.
That is true. So there are multiple ways in the NDA. Obviously, you may have it up on a PowerPoint. Let's say if you're in a room discussing with folks, it's on a phone call, or maybe you put it in an email. Obviously, if you put it in an email, it's easy to throw the word on, hey, this is confidential information. But pretty much every NDA that we enter into, we try to ensure that the folks that are exchanging information, whether it's you giving out system, intellectual property or confidential information from your laboratory or vice versa, that if you're doing it verbally, you have to reduce it to writing within 30 days is the standard. Not to say that that doesn't get negotiated, but that's typically 30 days. And you put it in writing and you keep that for your files. And so you want to make sure that everything that you do is documented quite clearly. And you may have more to also say for reasons to do good documentation on that as well. But
Well, yeah, I mean, for that kind of clarifies who contributed what. Same issue that we talked about before. So yeah, it's there for a good reason. Yeah, so please do that.
Yes.
Hi, I'm Brent Brockwell. How, in your experience, how do you evaluate a university technology that make sure it's licensable versus just interesting? And how do you work with the faculty to get them there?
Okay. There's a little voodoo in there. So, I mean, our licensing managers do, their homework mostly with the inventor going back and forth to try to understand, the technology and its potential applications. But in the end, is in anyone in industry interested. And so part of our work will be to start testing the waters, and finding some companies that would be in the space and start asking their opinion if they would have any, potential interests. And so we always start with something that's non-enabling, just a kind of a high level description so we can engage with the company initially, see if we can get some feedback. And, if they bite a little bit, then of course, then we get an NDA in place, share a little bit more information, hopefully even have a conversation have them pair up, to have a conversation with our inventor if it leads to that. But yeah, it's really, case by case, we take it and test the market ultimately.
I would say that's one of the most politically charged questions, and it comes down to the maturity of the faculty or the lack thereof, and the rapport with the licensing manager. Luckily, I'm blessed with Shamala in the back there, and we have a great rapport. And she puts me to the test. I mean, she asks me the tough questions, and I know faculty that have worked with Shamala that don't like that. And I say that's because they're immature. And if you can't handle a question from a licensing manager, you're never going to be able to defend it in court, I don't think. And so I see both sides. They're like, oh, well, this is my life's work. Well, yeah, and it's great research, but nobody cares other than you and the 10 people that show up to the conference you go to. But that's hard for a faculty to hear. And so I think that's one of the hardest things that the innovation office has to deal with is just because it's a good research project doesn't mean it's a good invention. And so that's something that I think A&M has to work on together. That's one of the things that we're trying to get a culture. So I look at it as, Shamala is part of my team. She's not out there, those innovation people, and then the faculty over here. And so we need to get that culture, I think, across the system a little bit better. And that's one of the things we're trying to change with the new leadership and Laura Lee and Sam Kim and Janie and everybody. And we're trying to really make that we're working on this together to make an impact in whatever it is that your area is. And maybe it's not now. So it could be, it's like, okay, not that it's not a good invention. It's not a good invention now. And so, but maybe in 10 years, when you perfect it, it might actually be worth something. So.
Yep. Thank you. Yes.
So in these times when funding is really tight for faculty, there's a good temptation to take on contract projects from industry. But I'm just wondering what the advantage for the faculty is. Does that funding count as external funding for tenure decisions? If it's really a defined scope of work that's being signed by the contract office, what's the faculty advantage?
Yeah, I guess.
Yeah, I think there's several, right? And so one, if you can get a long-term rapport, you can get a lot of really cool research out of the thing and move, again, more practical translational research. To be quite blunt, it really depends on the college and the department that you're in. Again, engineering, working with industry is considered a good thing. College of Science, it did not used to be, okay, because the goal there was National Academy of Science and Nobel laureate, particularly if you're in physics. And if you don't get that, then you don't achieve much. But I think it depends on the college, and that's another cultural change that I'm trying to implement. Even in the College of Engineering, there's some of that. I would call it nonsense, but going on at the college level where they say, oh, well, what's their H index and how many, and then, oh, but yeah, but that's industry funding. Well, they graduated a student. That student then went to work for that company. What's the mission of the university? It's several fold, right? And so I think you got to look at it holistically, and you can use that money to then further your research in maybe a different area that you weren't thinking of originally. So you're doing some fundamental research over here, but now you can say, I've got a practical application. And so really I've seen it progress over the 36 years I've been here. And it used to be bean counting, quite frankly, 35 years ago, but they are now at least putting impact into this statement. And so maybe you didn't get a publication out of it, but maybe that company sold that product and helped that community or whatever. And that's I would argue, a much better than impact than a Nature paper that, 5 people read.
You mentioned potentially using some of that funding to help fund some of your basic research. So what is the typical output that you would get? Like that would be a great advantage, right? If you got this contract and it was had overhead, are you free to spend that as you want? Does the university system have control of how you spend that? And then, what are you talking? Like if you have a contract, how much money can you get to filter through to your research?
Yeah.
So,
Go ahead.
oh, no, I was going to say, so for IDC or FNA, a lot of folks do see that as a tax, right? But it really does fund, the fundamental, administration, the building, the lights, everything that goes on for the research. That is distributed. It really depends on whether, I know AgriLife, there's a portion that goes to leadership, there's a portion that goes directly to the department, and there's a portion that goes directly to the PI. And it helps that money at the end of the day is put in an IDC account, and that money then can be used as for whatever you want it to, at the end of the day, if you need to buy equipment, if you need to support a student an extra semester, things like that, there is absolute value. The other thing that I do want to emphasize, and I'm so glad that you brought it up, is really the exposure. Students getting exposure to industry, getting practical experience with someone, if they're not going to be in academia, or even if they are, being able to work with private industry is really valuable. And you have exposure to someone else with a different, their mission is for the company, but you can see those different perspectives. You can work with someone and gain that experience, and it's practical, boots on the ground experience in many ways. A lot of times industry also does want to publish. It behooves them, right, to have someone with Texas A&M University or Texas A&M AgriLife research, as a co-author on a paper, and all of those things have a lot of value. And it's also diversification of a research portfolio, which also provides in the current landscape. I think it's always good to have that diversity of funding so that you're not reliant only on one source of funding.
Thank you. I have a question for Dr. Hanson, and maybe you can comment a little bit about the pathway towards international patenting.
Yeah, good question. So, I mean, typically, usually the way it will work is when you have an invention, you'll file a provisional patent application, and a provisional patent application is nice because it doesn't count towards the patent term. So patent term is 20 years. So you basically get 1 year, and you can file the provisional application. That kind of puts a stake in the ground for everything that's in that patent application. Then you have a filing date, and you have 1 year from that date until you file a regular U.S. application and or a foreign application. And so they're usually what people will do. There's what's called the Patent Cooperation Treaty. And so usually what you can do, and most of the countries in the world are a member of the Patent Cooperation Treaty. So what you can do is you can file one patent application, an international patent application, and then from that, so that's at the 12 months from your original provisional application, and then that will go through another process for another 18 months, and then you can file foreign. But the nice thing with that is you'll get a search report. So when you file that Patent Cooperation Treaty application, you'll get a search report, and they'll check the prior art, and they'll tell you probably before you spend a lot of money, because when you file in some of these foreign countries, like if you file in Japan, it's $15,000 just for the translations and the filing fees. And so it's very expensive. So if you follow the Patent Cooperation Treaty, then you can get a search report, And then it basically comes back and says, okay, and you'll have an idea, okay, this looks good. It doesn't look good. But if things look very patentable and then you had some time to assess the commercial value, then you can decide where you want to file. Sometimes people say, okay, I'm just going to file US only off of that. Or sometimes we file in 30 countries and, everywhere, including, Myanmar and, you name it. So really it just depends, but that's basically the way you would do it is at the 12-month date, you'd file a patent cooperation treaty application. And the only countries that aren't are places like Argentina, Uruguay, Paraguay, Taiwan, Pakistan. So there's, a handful of them, but most of the countries you can do that. And that's usually the way you do it because you can easily spend, hundreds of thousands of dollars for foreign filings if it's an important invention.
Rich Herwick from H2 1000. Ms. Hurley, I got to compliment your staff. Sheikh Ishmael, I can't say his name right. Sheikh Ishmael. It's not here tonight, but he's been helping me get my feet on the ground, and I appreciate him. My question is one of those, what's next? We have an NDA. We have technologies that we're looking at. How do we move the ball down the field toward commercialization? That's kind of open-ended question because we're a startup company. We've got funding, but we don't have salaries yet. Minor detail that we can't pay somebody to come work for us right now, but we will be able to. So what's next? I'm in the hydrogen business. I was working with Sean Nidhas, and he's went and got a real job. Excuse me for saying that. He went and got a industry job, and now I don't have anybody with this technology that I know of in Texas A&M. What's next?
Yeah. So you said there were some technologies though that you're talking about. So yeah, the next step is really a broader discussion with Ishmael to talk about, what your plans are. We first want to know, okay, tell me how you would utilize the technology. How are you going to deploy it? So we can have a conversation, start figuring out what the proper financial terms would look like, for an agreement. So usually it starts with a discussion. We don't like to propose just, throw over the wall some terms when we haven't had a discussion about it.
Yeah, this would be something that would be located either on campus or fairly close to campus.
Okay. Yeah, we should follow up afterwards because that's really the next step, and is having more of a detailed discussion about your interest in business plan.
I don't want to go around him.
Yeah, that's fine. Yes.
So a couple of questions. If you don't have a company lined up which is interested in your technology, who pays for the cost of patenting? And is it mostly the faculty who has to go out hunting for a company who may pick up the technology?
Yeah, so without a company yet interested in the technology, that's part of the risk that the innovation office takes and makes an investment to file the patent applications. And so we bear that expense, hopefully up into a time that we find a company that is interested. And then once we get a company interested, then the expectation is that the company would, reimburse those costs going forward, that they would cover the costs and then also reimburse the past expenses. Always nice for us to have, if the faculty member already knows companies, that may be interested, that's always good to share with us. So, we have a place to start. Otherwise, it's really on us to start looking at the market and potential companies. We do have a relatively small team in the office, market intelligence, that helps us do some of that research, that market research. We are still, kind of smaller with our licensing team, which is one of the efforts and push to expand our team, because it really is difficult for us to be able to spend sufficient time in doing all that market research and reaching out to companies like we need to be doing.
I know you'd asked the question for if you didn't have a company lined up, but I did want to say, I know there were some questions on the licensing terms and conditions. When we do have that in our sponsored projects, when you work with industry, really more than 9 times out of 10, they do agree to pay for patenting costs or reimburse AgriLife if an invention comes out of that sponsored project. So that is something that is also part of those discussions.
Mhm. Any other questions?
Oh, no.
Oh, I honestly didn't see you.
I don't get that very often. This is a question probably best answered, I'm guessing, by Rob. Inventorship. Who is an inventor? As a licensing manager, I see disclosures, and I have a good idea of what an inventor is, but it may have more credibility coming from you. I've seen disclosures that include a data sheet that says that the sponsor has a person that's an inventor because the sponsor provided the funding. I've also seen where a research administrator is an inventor because they administered the funding. So who really is an inventor?
Yeah, I'm always happy to be the bad guy. So you can blame it on me, but the statutes, set forth who is an inventor. So it's not who worked the hardest on it, who's most deserving. It's just according to the statutes, and we have to name it correctly. There are mechanisms to correct it after the fact, but to have a valid patent, you must name the correct inventors. And basically the standard boils down to the people who are inventors must have made a non-trivial contribution to the conception of the invention. The conception is the idea. It's not, and that's to be contrasted from what we call the reduction to practice. So conception is the idea, reduction to practice is making it work. So once conception is complete, inventorship is complete. So I just had the example today. Somebody filed a provisional application on this concept. All the concepts were in there. We named the inventors. Different people worked very hard the next year to kind of make that to make that work, to do a lot of research, to do a lot of studies, and we were given a list, and we said, okay, these other people worked really hard this last year, and they gave us great data that kind of shows unexpected results, all this other stuff. And they said, okay, should we name them? I said, no, because we didn't change the claims of the invention, because the inventorship was complete at the time of the provisional application. So it's the idea. So really in academics, it's very different, right, from publication. So it's very different from who you might name. And that's why I think, especially, we have technology coming out of university. Sometimes there's a lot of, and people have obviously it's important to your career, but people have a lot of, emotional investment. But unfortunately for us, it just has to be kind of an objective measure of the same standard that I mentioned, is who contributed a non-trivial amount to at least one claim in the invention. Good question.
I have a quick question. My name is Andrew from NCTM. And the question is, I kind of know the answer, but for the rest of the audience, we have a patent application in place. And what happened afterwards if the time period run out and no company interested in that? So what happened to that application? And can I pay for that to keep it for myself?
When you say run out,
so the provisional patent is like for a year or whatever number of months.
Okay. Right. So if no action was taken on the provisional application, it would basically expire at the anniversary date of that filing. So there would have had to be an action taken to convert that into a full, what we call a full utility application, to continue to seek protection for that invention. Now, something you can consider is if the invention had not been published during the time of the provisional application, then there's that you could look at reconsider, refiling the provisional application again, and kind of starting that clock over again. So, but that depends on whether or not there's been a public disclosure of the invention.
And I think there was a second part to that question, and that is, if you know you're not going to file it on behalf of the university system, and you know it's coming up to the deadline, would you release it to the faculty member or to the staff member, say like a month before, so that they could file it on their own behalf? And if you do that, is there some sort of agreement you make with that entity, that faculty member or that staff member, when you transfer?
That is an option. Yes. If it's something we determine that we're not going to go forward with, there's an opportunity to have the inventor request a release of rights, and there's a standard agreement for that.
Yeah, because I've done that. So when I was younger, 30 years ago, they don't do that with me anymore.
Any other questions? No. Okay. Well, thanks everyone for coming. We can let you all get to networking and just spend time, grab people. Real quick, I guess I'll ask for the Innovation Office employees if those folks could raise their hand. So for people that don't know them, give you an idea of who our staff is that you can grab if need be. Okay. Well, thank you all again very much. I really appreciate it. I want to give a hand to our panel again. Thank you very much. And have a good evening.